Do you live in Salt Lake, Summit, or Tooele County, Utah, and are being denied parent time by a non-compliant co-parent? Well, then I have good news and bad news. Good news, you can file a motion with the court to seek relief. Bad news, prepare to wait a while before your motion gets heard, and prepare to go to mediation first, regardless of whether you want to do so. The Expedited Parent Time Enforcement Program was created ostensibly to help resolve disputes over withholding or denial of parent time. The Expedited Parent Time Enforcement Program currently operates only in the 3rd Judicial District of the state of Utah, and the 3rd District covers Salt Lake, Summit, and Tooele County. The details of the Expedited Parent Time Enforcement Program can be found in Utah Code Section 801-9-102, briefly described, and to quote a portion of the statute itself, quote, if a parent files a motion in the 3rd District Court alleging that court-ordered parent time rights are being violated, the clerk of the court, after assigning the case to a judge, shall refer the case to the administrator of this program for assignment to a mediator unless a parent is incarcerated or otherwise unavailable, close quote. Currently, the way the 3rd District Court implements Section 81-9-102 results in unnecessary and unwanted delays in addressing and resolving parent time order violations. How? Because current practice in the 3rd District Court is as follows. 1. A movant files an ex parte motion to enforce domestic relations order and asks for sanctions. A proposed order to attend the hearing is also submitted to the court, leaving blanks for the date and the time for the hearing for the court to fill out. And you also submit a request to submit that motion for decision and to have the court set the hearing date and time. So far, so good. Then the clerk of court refers the case to the administrator of the Expedited Parent Time Enforcement Program for assignment to a mediator for mediation to be held within 15 days of the filing of the underlying motion. So far, still so good. But then the court inexplicably refuses to schedule the hearing on the motion until after mediation has taken place. Why? There's no statute or rule requiring this, and there's no good reason to do this. Neither 81-9-102 nor Rule 7b of the Utah Rules of Civil Procedure require this. Because the court refuses to schedule the hearing on the motion until after mediation has taken place, the amount of time it takes to dispose of the motion is protracted by at least 15 days, and usually in practice by much more than that. The way the courts enforce 81-9-102 sub 3 currently results in the following timeline. 1. File motion alleging that parent time rights are being violated. 2. Schedule mediation. 3. Go to mediation within 15 days of the date the motion was filed. If mediation cannot be scheduled to occur within 15 days of filing, then I read Section 81-9-102 3D1 to provide that the mediation requirement is waived or excused. I think most people do. But the fact is that often mediation cannot be held within 15 days, and rather than waiving or excusing mediation when that occurs, I have not encountered a single judge or commissioner who does not refuse to hear a 7b motion to enforce unless and until mediation has taken place. Okay, next, if mediation was not successful, and yes, mediation is not always successful, contrary to what you hear people say, setting the hearing date, to say nothing of the actual hearing date one gets when the hearing date is finally scheduled, has now been delayed by at least 15 days, probably more, because the 3rd District refuses to schedule the 7b hearing until after mediation has been held, even though there is no provision in Section 81-9-102 or Rule 7b for this. Well, so what, you may ask? Well, because Rule 7b requires that service of the order to attend the hearing be given no less than 28 days before the hearing date. The current informal policy of the 3rd District thus ends up causing needlessly hearings on such motions alleging that parent time rights are being violated to take place 45 days or longer after the date the motion was filed. 45 days or more. There's a better way. This is why I propose to amend Rule 7b so that the courts cannot delay the scheduling of a hearing until after mediation is scheduled or completed, as they're doing now. There is no good reason to refuse to schedule the hearing until after mediation is scheduled or completed. All that does is cause delay and waste time. And when parent time is being withheld, time is of the essence. What should happen is that when a court clerk receives a motion alleging that parent time rights are being violated, it should schedule the hearing at the same time it refers the matter to the Expedited Parent Time Enforcement Program, and it should do so immediately, of course. If the 3rd District will not do this voluntarily, then I propose amending Rule 7b to make clear that the 3rd District cannot delay scheduling hearings until after mediation is scheduled or until after mediation is completed. What do you think? And by the way, if the Expedited Parent Time Enforcement Program were to be expanded to other districts beside the 3rd District, or statewide, then I would ask that my suggested modifications to Rule 7b apply that broadly.